evening to one and all who have joined us here, all our viewers who are watching us live on YouTube channel or Facebook page. On behalf of DDS and Campus Law Center, I extend a very warm welcome. Today we have with us Mr. Amish Aggarwala, a Supreme Court advocate and a very popular face on YouTube and in the legal field. He has more than 8 years, almost 9 years of vast experience in providing legal consultancy and advisory services. He was a former associate with Senior Special Public Prosecutor, Directorate of Revenue Intelligence, and then he has been the Central Government Counsel and Dispute Lawyer at Supreme Court of India. Today, he's going to speak on the topic Art of Oral Advocacy, a topic which is very pertinent to all of us. This art of oral advocacy comes with a lot of experience and practice. And I'm sure today we all would be getting a lot of important insights from the topic from the sir himself. Thank you so much, sir. I yield the floor to you now.
Thank you so much, madam, for the very, very warm, very kind introduction. Coming to the art of advocacy, a couple of things that I have on many occasions talked about. This is something that I feel these are a few points that hopefully will and keep in mind, though, we are here, the debating society, but I have been invited to talk about the art of oral advocacy. I have already mentioned I have not had much of an experience when it comes to debates. So I am going to be talking about advocacy, the art of addressing a judge, and also trying to counter the opponent. And I feel that to a great extent, there is a lot of overlap, which is there anyways. So you will definitely have a few takeaways, even if you're preparing for debating in the near future. And once you are done and dusted with college life, when you go into the practice of law, and if you go into litigation, whatever you have practiced over here and learned over here are skills which will easily be transferred over into advocacy. One of the most important things that I feel everyone should understand and hammer into their heads about advocacy is that content always trumps eloquence. When I was in law school, I think I was in perhaps my third or my fourth year of law school. I was interning with an advocate on record at that point of time. One of the juniors of that advocate on record was this lady who I looked up to with utmost reverence. She was very, very eloquent. She was educated from a good college, from a good school, from a good college. She was one of those people who I used to think, wow, I mean, if I could speak like her, if I could, keep my head held up high like her, I'm sure I would have made it. Yet, when I saw her argue a matter for the first time before the Supreme Court itself, during that internship, I realized this lady suffered the same flaws that I did for a long, long time. That is, when you are eloquent, when you are well versed with the English language, when your grammar, your vocabulary, everything is on point. Often, and especially so because of lack of preparation of the actual meat of the matter, the contents of your file, the contents of the law, the facts which are there, you tend to stumble, stutter, stammer, and then all that glory that you built up in anyone's head and the person in front of you, all of that is lost. Even recently, I have a lot of collaborations with a lot of lawyers. One such lawyer I spent a lot of time with. This lawyer, in conversations with me as well as with other colleagues, always used to talk about his desire to be this eloquent orator, this effective, powerful advocate standing before the bench and making strong, thundering submissions. His English was, there was nothing lacking there. He knew the art and the craft of speaking. However, I believe he never really focused on the art of advocacy. Despite having gone to a very like a premier law school, despite having good training, despite having had the best of internships, one mistake that he made, which I believe I also made for the majority of years of my law school, was that we would focus on the manner, the thunder. We would be in awe of these people. But what we would not realize is the little nuances that were being played out in the court. And that is why I have come to the conclusion that it is far better to be thorough with your facts and with your law rather than hoping to be eloquent and sway the judge, because that does not happen. You could stutter, stammer, use English for that matter. What needs to be the focus is the content of your submission. If what you have to say is relevant, you will win. Now, this is a line that I read somewhere several years ago in an interview of some senior advocate somewhere. So I would love to give credit, but I don't remember where I read this several years ago. This senior advocate said that if you were to be asked what amount of preparation is required to address arguments before a court, a general rule of thumb is if you have to argue for 1 minute before the court, you must be preparing for at least an hour. 1 minute of submission, 1 hour of preparation. And I resonated quite a bit with that statement of that senior advocate. And this is what I would propose to you as well. Again, we circle back to the same point. The preparation is key. If you're able to focus on the facts, the law, and other sorts of preparation as well, you could take down the best of the best, the highest paid advocates in this country as well. I have no doubt about it. Now, there are certain other nuances that you must learn. And this is a curse which is imposed upon lawyers across this country for no reason, at least which I find palpable. Almost every single court has its own way of functioning. And when you start practicing before a certain court, a certain forum, you get comfortable with how things work with that particular court. But when you move on to another court, you will realize that whatever you were getting comfortable with, whatever you started thinking is the norm which should be followed. It is not a norm or a rule or a regulation of this particular court, but this is a generally widely accepted practice that must be followed by all courts around. When you go to other courts, you realize that this is not the case. Every court, complex, every court at different hierarchies have a very different system of how they work. And you would be at a huge disadvantage if you do not understand how that system works. If you try to bring in your methods, your ways of advocacy of whatever you have done in the past, or in the court complex, or the court, the district court, the high court, supreme court, tribunal, wherever it is you practice, if you try to bring that to the other court, you will suffer the consequences. I remember it was about a few months into my practice that I was appearing quite frequently before the Delhi High Court. And there was a certain belligerence that advocates had to and still have to practice when it comes to addressing arguments before most of the judges of the High Court. To a certain extent, quite similar to how it happens before the district courts. If you do not butt in, if you do not try to, But in your submissions, despite the other party making their submissions, or maybe the judge is doing something else, there is a very good chance that the judge will walk all over you and you will not get to make your submission. You need to push through. But when I got my first opportunity to argue a matter before the Supreme Court of India, about 3 or 4 months, about 50 odd appearances before the Delhi High Court. When I went to argue my first matter before the Supreme Court of India, I tried that same butt-in, tried to cut down the other person, and was immediately shot down by the division bench. And the senior judge on that bench said to me, "Young man, let him finish. You zip up, you sit down." And I had to face that embarrassment and I had to sit down. And but now the question arises, what can you do if you have to address arguments before an unfamiliar bench? This also, in a certain way, forms part of the art of advocacy. If you have to address your arguments, treat it like a professional sports person. Go and rewatch matches of your opponent and the field, the territory, how these things happen. There is ample time, especially when you are young, when you have to address arguments before a particular bench, you will have a lot of time to prepare. Spend some of that time going and sitting before that same bench before which you're supposed to argue your matter tomorrow, next week, or next month. So go and sit there today and observe how the bench deals with submissions. Observe how things are being argued, how it is being received by the bench. Because as I earlier said, it is a curse, but we have to bear it and walk with it, which is that we must mold ourselves, our submissions, even our facts and our law to suit the intellect as well as the emotion of the judge sitting in front of us. There are a couple of other aspects. There is also the constraints of time, energy, and resources as well. What I mean by this, I would be able to perhaps explain better with an illustration. When I was working with a senior special public prosecutor for this department, I was given the responsibility, and I'm very grateful for it, the responsibility of arguing about anywhere from 3 to 10 matters every single day before the Delhi High Court. And often I used to go to different district courts as well. I used to travel all over the place to make my submissions. But on most days, my duty was at the Delhi High Court, rushing from court to court. Me, an individual advocate with a few months of experience at the bar, trying to, and I started from day one. So every single day was a struggle. I was running around. But one interesting thing is that because I had to argue so many matters, I could not put in the kind of preparation that ideally I would want to as a young advocate. Because for the smallest of things, the opponent can steal away from you relief that otherwise they would not have gotten if you knew your craft, or if you knew about the law, or about how facts are interpreted by the court in a certain way at a certain point of time. What happened was then that I had to force myself to absorb huge amounts of data in a very short amount of time. And of course, because of the fact that I was absorbing huge amounts of data in a very short span of time, I had to cover large lengths and breadths of every subject matter instead of trying to go deep into any one subject, which was understandable. My boss was happy because I was able to deal with all of these matters. No government council expects perfection, especially majority of the matters. There are some special circumstances for which we had to kind of make that exception. But on most days, my art of advocacy was also molded in a certain way to go through a lot of files, prepare a lot of matters, and prepare myself to argue a number of matters every single day. But when I went independent, I had a lot of free time on my hands. I barely had, especially in the first few months of going independent, I had maybe 3 or 4 hearings in a month, and sometimes the whole calendar was completely empty. And it was on those occasions that I found myself with a lot of time to prepare for each and every single matter. And in those times, I was able to very effectively go very, very deep. But at the same time, there what I realized was that when I have understood so much about the subject, to condense all of that information pertaining to the case into a small capsule that I can then feed the honorable court is also something that I struggled with for a long amount of time. And I feel that till date, one of the biggest challenges for any advocate is to condense large amounts of data, hack at it, and make it as concise and as powerful as it can be. And I realize that this is the biggest sticking point that most junior advocates will also struggle with, because of the fact that whenever I have my colleagues who work with me, whenever I, in a way, brief them about what they have to argue, when they have to go and argue matters in courts, I always see that they are very, very thorough with the file, having spent anywhere from 5 to 50 hours preparing that file over a period of 1, 2, 3, 4 days. But a big concern with each and every single one of the younger, less experienced colleagues that I have had is the difficulty with picking and choosing exactly what to say to the judge first, what to say to the judge next, what to say last, and what to keep out entirely from the view of the judge when it comes to your submissions. And that is why on a lot of occasions, especially when they're starting out, I would practice with my colleagues and I would ask them to tell me, to assume that I am the judge, and when the matter comes up, to make their submissions before me the way they would before the judge. And every single time, there will always be, especially in the first few occasions, there will be a lot of hesitation. There will be a lot of resistance, and this is the same hesitation and resistance that you will find when you are standing before the judge. But at least when they've practiced it out in front of the fake judge for a couple of occasions, a little bit of course correction has been done again by the fake judge, I have found that they have been far more effective in making their submissions. So one of the most important things that I feel you guys could take away from this is that you need to put in the effort of understanding your facts and your law of your file. Second is to understand the judge, and third is to practice to such an extent that you can take on whatever is coming to you. And another aspect to this is, if you want to learn advocacy as soon as possible, the best thing that you could do is to find clients of your own. But there are certain moral dilemmas that one faces, or at least I faced when I was very young, and through maybe say family members or through friends, and through a lot of luck as well, I would come across paying clients who would pay me to research for them, draft for them, file for them, and then go argue matters for them. But so you learn a lot when you are arguing your own matters. But the moral dilemma that I used to suffer, and to a huge extent, some people might suffer, is that you are learning at the cost of your client. The client will suffer in one way or the other, be it on the merits of the case or your procedural weakness. But this will be the biggest lesson for you. If you want to save on your moral, save yourself on your moral dilemmas, and also have a little bit of, and also accelerate that learning process, it's nothing better than to join a senior who allows you to argue matters. And if you don't have any such situation like that, I would recommend gather a bunch of friends and start practicing with each other. And trust me, it might look a little ridiculous. But I have seen the power of masterminds, be it in the profession of law or be it in any other sphere of life. A couple of you people getting together, having a similar goal, of course, and practicing towards that goal and giving each other feedback. And on a lot of occasion, more importantly, giving each other encouragement. If you're able to do that, even if you have no clients of your own, you have no seniors right now, you have nothing with you can still improve yourself and you can be ready for the day that you can have your senior and be ready for the day that you have your clients.
Sir, it was indeed a very informative session, I would say, and I'm sure everybody has learned so much from you today. Thank
Thank
you,
you for
sir. Thank
this.
you so much.
I'll take your leave then. Goodbye, everybody, and very good luck with whatever is going to happen with the debating and discussion society in the future. Bye, everybody.